Please welcome Marian Bloodworth, co-chair of the City HR Consultation, Legislation, Advice and Policy Committee. That's a big title. Yeah. And chair of the National Training Committee for Employment Lawyers Associations.
Thank you very much. Good morning, everybody, and thank you for the invitation to speak today. I'm going to rest up there. If anyone sees it fall off, give me a shout. But thank you. As Matt says, I'm an employment law partner at Kemp Little. We are a boutique law firm. We specialise in technology and digital media. We love tech, which probably not lots of lawyers say, but we genuinely do. Traditionally, that meant we supported software technology companies, but of course, as we've heard today, technology is being used in every shape and size of business in lots of different ways, and so our client base is very diverse, and we support lots of different clients. I have a particular interest, therefore, both in tech, but as an employment lawyer, in issues around diversity and discrimination. And as Matt says, that's what I've been asked to talk about today. There is loads of technology in the workplace, and we're all trying to use it in a way, as we've heard from Graham, that frees us up, allows us to do things better and quicker, and to keep our people focused on the things that really need their attention. But inevitably, there are some legal risks and aspects that we need to be aware of when we do that. And so, whilst there are benefits, I want to talk to you about the things that I think you should have on your radar so that you're already thinking about them and you're prepared. So, I'm not a professional recruiter, but I have done enough in the law firms that I've worked in, and this is my sketch of what I would guess you would think a perfect recruitment process would look like in the ideal world. So it starts with a nice lot of clarity up front. You know exactly what you're looking for. You've got some keywords and some attributes to help you with that search. Ideally, there's a big pool out there of suitably qualified people, nice and diverse, not just all white, English, narrow field. You've then got a selection process that allows the best potential candidates to be identified, interviewed and shortlisted as quickly as you can. Minimal or no legal or reputational risk, so your lawyers aren't worried and your finance department's not worried and the PR team aren't bothered. Then you have a selection method that identifies the best candidate. You make them your offer. It's too good for them to refuse, and you've got them. So you may well have lots of other bits to add to that, but I think that's roughly what we're after. But it is possible that discrimination can infect a recruitment process. So let's just remind ourselves what discrimination means in the legal sense, because obviously that's what I worry about, and it's what HR folk and L&D and recruitment teams worry about. And that's where somebody with a protected characteristic is treated less favourably during the recruitment process. And just a reminder, the protected characteristics are defined at law. So they're on the slide there, but it's the ones you probably will be thinking about: sex, race, age, disability. But increasingly, as the years have gone by, we've added more and more protected characteristics to our legislation to ensure that people are properly protected when they're applying for jobs and when they're in the workplace. So it now includes gender reassignment, sexual orientation, marriage and civil partnership, pregnancy and maternity, and religious and political beliefs. And then what kind of claims can somebody bring who thinks they've been treated less favourably because they've got one of these protected characteristics? Well, I've set out the key ones that apply, particularly during the recruitment process here. So we have direct discrimination, and that is where you simply don't choose somebody because you think that sex won't fit in here or they're too old. There is no defence to that. If you're found guilty by a tribunal of that, it doesn't matter what your justification is, there is no defence. The next one, which I'll talk about a bit more later on, is indirect discrimination. And that's where you apply something like a selection process that on the face of it applies to absolutely everybody, but actually it has an adverse effect on a particular group of people. And you'll only be allowed to get away with that if you can justify why you have that process or that criterion. And the way in which you've gone about supporting it is proportionate. And then when we think about people with disabilities, which again is very relevant during the recruitment process, there's two that you need to think about in addition to direct and indirect discrimination, both of which apply to them too. And that's your failure to make reasonable adjustments. So that can be in the context of recruitment, making arrangements for the interview, but even, and I'll come on to talk about this, in the way in which you test, in the way in which you select, there may be changes that you need to make to those processes to properly accommodate someone who's got a disability. And then the last form of discrimination, and this is unique just to disability, is discrimination arising from a disability. So that's where you treat people in a particular way, and it's unfavourable. And it looks as if it's just a normal objective reason for treating them. So the classic example actually is usually around absence. You terminate somebody who's been off sick because they've been off for too long. But of course, the reason they've been off is because they've got a disability. And that will be discrimination arising from a disability unless you can justify it. So where might a discrimination claim potentially arise in a recruitment process? And let's have a think about, in reality, who's going to bring a claim about discrimination arising from recruitment. It's going to be someone who is unhappy, either as they're going through the process, but probably in reality when they haven't been selected. So they'll have gone through everything that you impose as a process, and then at the end they haven't been selected. And people who don't think they've been treated fairly or properly will cast around for reasons as to why that might be. And somebody with a protected characteristic has this additional protection from the law. So they might then say, well, do you know what? When I actually applied, the language in the job advert was really male-oriented, to be honest. I felt from the outset that as a woman, I was never going to get that job. It was clearly after a thrusting, young male employee. Maybe during the selection or interview process, they were asked inappropriate questions or questions that revealed bias on the part of the interviewers. I'm going to talk about automated processes because that's why I'm here, but you'll see that there is some potential for risk there. But also even in pay design, so you offer them, they may not get to that point, other people may complain about what the pay that they're being offered, if it perpetuates inequalities of pay within an organisation. So those are all areas where the risk can arise. And because there is no length of service criterion for a claim, it doesn't matter that this person never ever joins your organisation. They can still bring a claim against you. And what they try to create is a picture of a discriminatory environment. So they'll say, the language wasn't good in the job advert, I got some very aggressive, sexist questions during the interview process, then the shortlisting I wasn't convinced about, nobody got in touch with me. And they'll just try and create an image of an organisation that isn't properly diverse or supportive, and that is potentially discriminatory. And then why do we worry about this? The HR folk in the room will know exactly why, as will the people who control the budgets. Legal risk is never something that you want to embrace. Compensation for discrimination claims is unlimited. It will incur legal costs. There'll be lost management time in revisiting the interview process. Who said what questions were asked? Why did we not select this person? I can't remember. I didn't take any notes. All sorts of stuff that's going to take up time. But obviously, it has other impacts, even from a legal perspective. When you go through procurement processes, when you go through RFPs, quite often you will be asked nowadays about your diversity and inclusion record anyway, but also specifically whether you have had any complaints, whether you've had allegations of discrimination, and whether you've had claims brought against you. So that's the legal risk, but putting that to one side, obviously you're worried about reputational risk, because the person who's had an unhappy experience with you and who thinks they've been discriminated against, and let's face it, that's discriminated against for something that they have no control over, so their sex or their disability or their gender, their ethnicity, they're going to tell their friends. That's going to have a negative impact on your brand. People use social media, as we know. Word is going to get out. And people always talk about their negative experiences on the whole far more than they do their positive. But I would have thought the key for you guys is this. You maybe got lost candidates. You've got people who've been turned off. Maybe your systems and your processes are not allowing you to see an appropriate pool of people. So this is where AI comes in. It can help you to mitigate that discrimination risk. So it can help you at the outset to identify more potential candidates on a much more objective basis. And remember that if you've got an algorithm running this for you, or a computer, it's not influenced by the existence of protected characteristics. It's just got some data to deal with. It doesn't see someone's name. It doesn't form judgments about it. It might well be able to minimize the risk that semantics and language that the candidates use in their application process could put off a recruiter. And there might be advantages to certain demographics there. So, for example, if your AI does a contextual search and not just for single keywords, that can help to minimize the risk of language and semantics issues that could inadvertently mean that, for example, older people or people for whom English isn't a first language are otherwise excluded. AI is brilliant in that it doesn't get tired, it doesn't get distracted, it's not got its mind on its shopping list or when the kids need picking up. It doesn't follow preconceptions or fall in line with louder voices. So if you think about those who might lead recruitment processes and sometimes know exactly who they want and they're not willing to consider other candidates. It also, on the whole, doesn't seek to recruit in its own mould. It just deals with the data that it's got. and therefore it can help to level the playing field. It can also help you reduce the number of unsuitable candidates. But what we then need to think about is whether this is entirely risk-free. And we're not the only people thinking about this today. I've got a selection coming up of headlines relatively recently because lots of people are thinking about this. It's come up in the context particularly of banking. You might have seen lenders are using algorithms to decide who to lend to, but the risk is that those algos are discriminating against people from particular postcodes, and then when you drill down, for example, into who lives in that postcode, you'll find that they tend to be of one ethnic origin, or more people of that ethnic origin live in that postcode. So there's just, as I say, a few headlines here, and this is where we sort of come to the realization that our technological advances are not necessarily keeping up with our laws, with our ethics. There's another one, the struggle to make AI less biased than its creators, and how to keep your AI from turning into a racist monster. You might remember that last year, the Microsoft chatbot got pulled down pretty quickly because it was responding and learning from the content of people who sent it messages. But pranksters and trolls started feeding it racist, white supremacist comments, with the result that it then started using that in its communications. So that just goes to show that you do have to be alive to the risks of this technology. And as I say, it's got limitations. As we saw from that headline, its AI is designed and programmed by humans, and then the output of it is reviewed by humans. It does require precision in the information that is uploaded for the system, the AI, to run on in the first place. There's a risk that it doesn't have enough flexibility, and there is a risk that it can't take into account context. So it can't take into account the stuff that somebody would tell you if they were in front of you at an interview or they were talking to you about whether they should apply. And as we've seen, the real risk is that it can perpetuate or it can automate, even worse, unconscious bias. So if it's been programmed to select and look at things in a particular way and thereafter runs every single selection process based on that, that will just continue. And I guess it's possible there will be some candidates who have reservations about supplying their data to be used in this way. So you may still not have a complete candidate pool. And obviously, this is where the discrimination risks come in. So if, for example, the AI is programmed to rate poorly or exclude altogether, for example, people who are showing gaps on their CVs, the real risk is that you will be excluding anyone who's had a period of family leave, anybody who's had a period of illness and some sick leave away from work. The other risk, I think, around age is that some people may be less familiar with technology, the way in which they need to input their data, so it may be incomplete or look inaccurate. They may then get selected out. And particularly on disability and the hidden disabilities, so the Asperger's, the autism, those people may not fill in or supply data in a format that you would expect, and it may be missing particular bits of information or be otherwise incomplete. And as I say, there's issues around language potentially for people when you're recruiting in the UK for whom English isn't their first language. Of course, then the big question is, and that's where the lawyers get all excited, who's liable? And we've heard from Graham this morning about the driverless cars, and that is where that very first issue has arisen, because if you are in a driverless car and for whatever reason it crashes, who is liable for that? We talked about the insurers. We talked about the driver. What if you were in a driverless car for work? Is your employer liable for that? And again, as I say, this highlights, I think, how the law has got to catch up with all these technological advancements. So if we're thinking about our unhappy candidate, somebody who wants to bring a claim, to be honest, they're going to go probably to the end of this arrow, and they're going to raise their complaints with the hiring company, the employer, to whom they wanted to apply and where they wanted to work. But if you're an employer and you've used a bit of kit, or you've asked somebody in the middle here to run the screening process on your behalf, to apply the AI, well, you might be a bit peeved to be sued because you might think you'd got a really good bit of kit that was going to stop you getting discrimination claims. So it's possible that you, in turn, might look to bring into that claim the people who ran the search for you, and even potentially the system designers. So there is liability both for the employer, but also anyone who effectively operates as their agent. So that's someone to whom you've given the power to select and to sift on your behalf. And there's also a separate liability for knowingly assisting somebody. So if you highlight and identify that there is discrimination risk in your process, but you all carry on using it, it is possible for you all to be brought in to the loop together. And I just wanted to highlight, there's been a couple of cases recently, which is kind of quite, I think, helpful for us and puts this on the radar in a very real way, because this shows you what happens when you apply testing requirements to people and where the discrimination risk arises. Now, you may have seen this case, a Home Office one. Anyone who wanted to be promoted had to go through a core skills assessment test, and Mr. Aesop failed it. And the Home Office had statistics that showed that BME and older candidates had significantly lower pass rates than white and younger candidates, but nobody knew why that was. But nonetheless, this test was still being used. So he pursues a claim for indirect discrimination on the basis that whilst the test applied to everybody, the Home Office already knew that he was in a pool of candidates who were far more likely to fail it. Now, this is a bit of a technical issue at the tribunal, was did he need to show why that requirement to pass the test placed him at a disadvantage? And they've all held that there's no need for him to show why it placed him at a disadvantage. It's just enough that he falls within that group. So by virtue of his ethnicity, he fell within the disadvantaged group. So that's now gone back to the tribunal for them to consider why exactly it was in his case that he failed that test. But that has gone all the way through the courts. It's involved the Home Office in lots of legal arguments. And you can see why discrimination has the propensity to tie up a lot of managers and engage a lot of cost. And then the other one, even more recently, is Brooks and the Government Legal Service. Now, this is around disability discrimination in the recruitment context. And the GLS gets thousands of applications every year for people who want to be a trainee there. And they can't possibly have someone sift through all of that. So they use psychometric multiple choice questions to sift through. Now, the claimant found out about this, but she has Asperger's syndrome. So she said, I'm not well suited to multiple choice questions. I'd prefer to do short contextual answers. Can I do the test in that way? And they said, no, sorry, because we like to run all these answers through a computer because it's much quicker for us that way, and this would involve a human doing it. But to tell you what, you can have some more time to do the test, which wasn't what she'd asked for. So she fails the test. The pass mark is 14 out of 22, and she gets 12. So her career at the GLS is over before it's even started. So she takes the claim to tribunal, where she wins. She takes it to the Employment Appeal Tribunal, because the Government Legal Service appealed, and she wins there as well. Now, what the employer was trying to say was, look, we have all these thousands of applications. This is a really cost-effective way for us of managing this. But as you may know, cost is never a defense to discrimination, because otherwise we'd all use that argument. They also tried to say the test is very similar to what she actually has to do in the workplace. So it's almost a genuine occupational requirement that she's able to do this. But I can tell you now, if my job as a lawyer involved answering multiple choice questions, I don't think I'd be here, and that just wouldn't be the job. So they failed on that defense as well. And in fact, she got some compensation out of them. They were ordered to apologize to her, and they were ordered to review their recruitment processes. Now, you might think that's particularly harsh as a result for one person. But of course, what it showed was that a reasonable adjustment much earlier on in that process would have saved them all of this, because they could have let her do the test in the way she asked for and had one person look at it. There was no suggestion that they were swamped with requests for reasonable adjustments so that it would have been unworkable. So just having a think about practical tips. So you've got this fabulous technology. It's saving you time. It's hopefully delivering you a better candidate base. What do you need to be thinking about? Be aware of its positives. It can genuinely speed things up, and make sure you use it for those things. Use it appropriately. It also doesn't get tired, so it can keep working when you're in bed. But you do need to be aware from a legal perspective of its limitations. So how can you do that, and what steps can you take? You can audit the process for bias. Continually evaluate the results that your AI is throwing up for you. Are they what you expect? Recognize all the things that it can't do, and where genuine human interaction is important, so identifying someone's potential, their ability to empathize with the issues, their propensity for risk-taking. If you're briefing somebody to set some AI up for you, think about what you want it to do, and potentially document that rationale, because if you can show at a later date that you had good reasons for setting it up in that way, that may well assist you. And if you're involved in the design of this at all, train the coders, the designers, and the end users to recognize the risk of bias. And I would say this, wouldn't I? But it is worth taking a bit of legal advice, both in relation to your contracts with those coders, designers, and suppliers, but also just to evaluate the brief that you're giving in the first place. What is it that you're looking for? Now, I'm conscious of time, and these slides will be with you, but I wouldn't be doing my job talking about legal risks in recruitment if I didn't just highlight data protection. You'll all know, I'm sure, about the General Data Protection Regulations, which we are signing up to even though we are leaving the EU. It's a far more onerous regime. The fines will be higher. There are going to be many more obligations around consent, about the legal purpose, why you're processing people's data. But the important thing from an AI perspective is this new focus on profiling. And that is where you take a decision based on, well, a bit of kit takes a decision about a person based on any of these things without human intervention. And there are going to be some clear safeguards in place for that. And I'm sure this is a talk for another day, but it's just worth remembering that you need to keep these in mind to make sure that you don't expose your profiling systems to risk. And hopefully, Matt, that has delivered for you without.
Thank you very much, Marian.
Yeah,